Welcome to the Mulcahy Law Firm podcast. For over 25 years, Mulcahy Law Firm has helped plan communities and condominium associations throughout the state of Arizona. Please go to iTunes or your favorite podcasting platform and leave us a rating and a review. Thank you for listening. Here's Beth Mulcahy.
Good morning, everybody, and welcome to class number 11 of our 2025 virtual HOA Condo Academy in partnership with the cities of Avondale, Chandler, Glendale, Goodyear, Mesa, Peoria, Phoenix, Scottsdale, Surprise, and Tempe. My name is Beth Mulcahy, and I'm the founder and senior partner for the Mulcahy Law Firm in Phoenix, Arizona. This month celebrates our firm's 29th anniversary. Can't believe it. It's gone by really fast, some years longer than others, but for the most part, it's been a very quick 29 years. Our firm currently represents over 1,000 planned communities and condominium associations throughout the state of Arizona. I also currently serve on my HOA board and have for many years. In this class, we're going to be covering the top 10 things you need to know about community association law and what are some secrets to have successful association. This bootcamp is designed to equip you on how to avoid common pitfalls, achieve success in your association, and get things done effectively. We're also going to have a question and answer session at the end, so come prepared with your questions. As always, when we address questions at the end of our class, I'll conclude our presentation, hopefully right around noon, and we'll move right into the questions at that time. Due to the large volume of attendees today, please note that there is one question per attendee. If you're joining us on Zoom, please submit your question in the Q&A box. If you're joining us on Facebook, please type your question in the comments section. First, we're going to start out with the poll. I know that this is already on your screen. It's really helpful for us to know who's attending and what your role is so that we can tailor the class. First question is, which city do you reside in? If you're joining us on Facebook Live, be sure to just indicate which city your HOA or condo property is located in. And then if you're joining us on Zoom, you'll see you can answer the poll question directly. Poll question number 2 is, let us know your current role with the association. So are you a board member, a community manager, an interested homeowner, or other? Okay, we're going to come back to the poll results here in a few minutes. So we will get back to that maybe towards the end of after we finish the first section here. But let's get right into what are some important things 10 things you really need to know about community association law as a starting point. When we were preparing for this class, I really tried to think about, okay, what are the things that if I were new to a board, what are the things that I should bring to your attention? Or maybe if you're a current board member, when you want a refresher, or maybe you're a homeowner thinking, gosh, I'm not sure my board's handling things properly, or I don't know the answer to some things that are going on in our association, like can we request records, or is our board following the open meeting law? We're going to be discussing the 10 things that I think every board member, homeowner, or manager needs to know if you have involvement with our industry in any capacity. Okay, so the first one we're going to start out with is probably the one I talk about the most, and this is the Arizona open meeting law. And basically, there is a statute in Arizona that pertains just to condominiums and planned communities. And it is the open meeting law. And it's different from the open meeting laws that may apply to school boards or to municipalities. We have our very own special open meeting law for condos and planned communities. And it's actually pretty easy to follow. So let's just go through it step by step. Okay, under Arizona law, anytime a quorum of the board is meeting to discuss association business, it needs to be an open board meeting. So less than a quorum, it doesn't need to be an open board meeting. So what do we, and a quorum or more, we need to follow the open meeting law. And so what does that mean? That means that an open meeting is that your board properly notices it 48 hours in advance of the meeting. And that can be done by conspicuous posting, or it can be done by putting it on your website. It can be done by sending a reminder email. All of these are effective ways under the law to notify your residents of a meeting 48 hours in advance of the meeting. The meeting, just so you know, is open to any owners and any designated representatives of owners. So owners is kind of easy. We just check to see who is the record owner under Maricopa County or whatever county you live in. On the assessor's office or the recorder's, we know who the record owner of the property is. But the owner can also designate somebody in writing to attend the meeting on their behalf. It doesn't happen very often, but sometimes you will get that request. And maybe they have their attorney or their realtor or their tenant come to the meeting on their behalf. But the only legitimate legal way that that person can be there if they're not an owner is if the owner puts it in writing that that person is their designated agent. Another thing that's kind of important to know about Arizona open meeting law is that all meetings must be held in the state of Arizona. Now, this became a little tricky with the pandemic in 2020 because a lot of us switched to Zoom meetings. And frankly, most of our clients, I'd say probably 90% are still meeting via Zoom or maybe a hybrid format. And so how we handle this typically is if it's an all Zoom meeting, what we will do is have a location somewhere, maybe at the management company's office or the attorney's office, or maybe a location at the association where if an owner wants to attend in person, they can go to that location in Arizona and then the Zoom is up on the screen. In addition, another requirement of the open meeting law, so we've got that anytime a quorum of the board is meeting to discuss association business, it has to be an open meeting, right? 48 hours notice to the membership prior to the meeting. We talked about designated agents can attend as well as designated agents in writing, as well as record owners can attend. In addition, the board has to also provide an agenda with the meeting notice. So the agenda of the meeting should state with reasonable particularity what is going to be discussed at that meeting. Let's see, what would be some other good things that we can talk about? A portion of the meeting may be closed where we go into what we call a executive session meeting. And that is when the board it's just typically the board and maybe a special guest like your management company or your attorney. And if that happens, the meeting notice, you have to always notice the executive session too. So you have to provide the 48 hours notice of the regular board meeting and also 48 hours notice of the executive session. Now, most of you will be having an executive session and a regular board meeting the same day or evening. And so you do need to notice both on the same notice, and you do need to give an agenda for both. Now, the executive session is going to be, you're not going to be able to give very much particularity because we're talking about executive session topics. But you do need to provide the notice for both the regular meeting, that's the open meeting, and the executive session meeting. That's a question I get very often. Do we still need to notice the executive session meeting? Yes, you do. So what can we go into executive session for? There's 5 topics under Arizona law that we can go into executive session for. And again, before the board closes a meeting to go into executive session, if the agenda and the notice don't indicate what you're going to be discussing, and that would be best practices, just put it right on the notice. We're going to be discussing, this lists the statute number, which is either going to be 33-1804 if you're a planned community or 33-1248 if you're a condo. Or you can just state that we're going to be talking about one of these 5 topics. And the 5 topics you can go into executive session are these topics. So number 1, legal advice from the attorney for the board or the association. Number 2, anytime we have contemplated or pending litigation. Number 3, anytime we're talking about the personal health or financial information about an individual member of the association, an individual employee of the association, or an individual employee of a contractor for the association. The 4th category we can go into executive session for is anytime we're talking about job performance of, compensation of, health records of, or specific complaints against an individual employee of the association or an individual employee of a contractor of the association who works under the direction of the association. And lastly, the 5th topic we can go into executive session for is anytime we want to discuss an owner's appeal of any violation which has been cited or a penalty, like a fine or penalty that's been imposed by the association, except if the owner wants it discussed in the open session. So just to kind of summarize the executive session topic real quickly, it's a subpart of a meeting, of an open board meeting. It's typically going to be just the board and maybe the manager, or maybe board, the manager, and the attorney. Occasionally the attorney will attend if there's a serious legal issue or there's some legal advice that the board wants direct input on. We still have to give the 48 hours notice of the executive session. We also encourage you to give the agenda and to state on the agenda that what section in the open meeting law that you're going to be closing the meeting for and discussing during executive session, because that is required under the law. What are some practical examples of what we go into executive session for? Delinquencies, violations, advice from your attorney. A typical example would be maybe I write an opinion letter and the board's going to be discussing it. Or maybe I attend. I attended a board meeting last night on behalf of one of our clients on Zoom. Maybe I've sent an email to the manager. Maybe the manager and I had a phone call and the manager's relaying what my discussion was with him or her. Another common thing that we go to executive session for is if there's active litigation and I want to give an update, or maybe we're thinking about suing somebody and maybe the board's talking about that. Another good example of things that we talk about in executive session, if there's something unusual that's happening with an owner, like a health issue. Recently, we've had a number of instances where maybe we have an owner who is suffering from dementia or Alzheimer's, and we've received communication from a neighbor saying, hey, we're really concerned about this person. That would be a time we would be discussing that in executive session. Another time we typically will go into executive session is if we're talking about our vendors or our employees and we're doing like maybe a review of them, or maybe we're talking about a bonus at the end of the year or their compensation. All of those topics are topics that you can go into executive session. Now, that being said, the most common every month executive session topics you have are going to be delinquencies and violations. And maybe if you are getting advice from your attorney, those are kind of the most common things that you go into executive session for. A couple things that you need to be aware of, just some nuances of the open meeting law. The agenda must be available to all owners at the meeting. And so a couple ways you can handle that. You can, if you're meeting in person, have a stack of them right there so anybody who's coming in can grab one. If you are meeting on Zoom, you can have it posted right on the screen at the beginning of the meeting. You could send out the agenda, like we said, with a notice, but you also have to have it at the meeting as well. If you have an emergency meeting, so occasionally we'll see a board having an emergency meeting on a topic that we can't wait 48 hours to notice the meeting and then conduct the meeting. And there's special procedures for an emergency meeting. But I want to first start out by talking about like what is an emergency, because I get this question pretty often. So a common emergency would be like a tree fell on the common area clubhouse and cut the clubhouse in half, or maybe there is an insurance claim that needs to be made immediately regarding a serious health or safety issue that happened at the association. Or maybe you have been named in a lawsuit and you want to talk with your attorney quickly. These are examples of emergency topics. And kind of the rule of thumb on emergencies is if you can't wait 48 hours, then it probably, to make a decision, you will want to push it into the emergency category. Okay, so there's some special procedures if you have an emergency meeting that you need to follow. Basically, you have to take minutes at the emergency meeting. You have to read into the record at the next regularly scheduled meeting of your board, next regularly scheduled open meeting of your board, what was discussed, and attach the minutes to the next meeting minutes. You also have to indicate what the emergency was and any decisions that were made. And that's just for transparency, because if you're having an emergency meeting and you can't notice it, owners won't be aware of any decisions that you made. And so you want to be sure to make sure that there's a paper trail through the next board meeting as to, hey, we made this decision outside of a regular board meeting, and here's why, and here's what we did. A couple other things, questions that I get very often. What if our board is meeting and it's a quorum of the board? So let's give an example. There's 5 board members in an association, and 3 of the 5 is going to be a quorum typically. And we're not making any decisions. We're just talking about the budget, or we're just doing some long-term planning for our community. Does that still have to be an open meeting? So the short answer on that is yes. Anytime there's a quorum of the board meeting discussing association business, it does need to be an open board meeting. The workaround on that would be to have less than a quorum, talk about the issue, and then maybe report back to the board, or have the board president individually talk to board members, which would be less than a quorum if you have a board that's over 3 people. One other thing I want to mention is that under state law, it actually says this right in state law, that interpretation of the open meeting statute is to be construed in favor of open meetings. And so I think the legislature and courts have made it abundantly clear that this law is in place for transparency. Owners should be allowed to listen to the decisions that the board is making, and It's really important that association board members, when there's a quorum making decisions, it needs to be done in the open session, unless it's an executive session topic or unless it is an emergency. A couple things I want to just mention real quickly is on recording meetings, open board meetings. So there was a law that was passed this year in our legislature, the 2025 legislature, that talked about recording board meetings. This law is kind of predated. It maybe is about a decade old, if I had to guess. And it did allow owners, if they wanted to audio or videotape meetings. And so that law has been on the books for, like I said, at least a decade. However, the new law that just went into effect on September 26th this year indicated that if the board is taping the meeting themselves, they are required to keep a copy of that recording for 6 months and make an unedited version of that recording available to any member who requests it in writing. So it's just kind of an extra step that the association has to take if they're recording it. And like I said, most of our clients are using Zoom right now to conduct their board meetings or some other platform, and they are recording the meeting. So if the board's recording a meeting, you are required to keep that recording for 6 months. After 6 months, you can destroy it. But that is the law now in Arizona. And so you need to be mindful of that. And if an owner wants to see it, you cannot edit it. You just provide the recording link to the owner. Okay, so we have a great turnout today, and I'm just going to go back to the poll results because those are now in. Looks like we have a lot of great attendance today. So in Avondale, we had 1% from Avondale, 11% from Chandler, 2% from Glendale, 3% from Goodyear, 34% from Mesa, 7% from Peoria, 12% from Phoenix, and 14% from Scottsdale. Let's see. I think maybe my office. Let's see. I think we are just getting the numbers in here. So let's see. We have 8% from Surprise and 7% from Tempe. So really good turnout today. I guess Mesa wins Surprise for the highest percentage. And it looks like Scottsdale might be the next one. So that's amazing. And Phoenix is a close third with 12%. Also on poll question number 2, what is our current role? We have board member is 64% of you are here today. That's great. 1% community manager and 30% interested homeowners. So a lot of homeowners here today, which is great. And then 5% other. So really great turnout from all the different cities that we're teaching these classes with. It looks like we have over 162 people on Zoom today, which is amazing. And 131 of you participated. So I really appreciate that. And many others on Facebook. So great turnout. Okay, so we just finished our number 1. This is kind of the longest one that we were going to do today in terms of our topic. And it truly is one of the most important topics for board members, homeowners, and managers to be aware of, the open meeting law. So let's go on to our next ones. The next ones are kind of a little bit more in and out quickly, but also equally important. The next one is kind of one that we don't see as often, but it's important for your boards to be aware of it. So solar energy devices. So Arizona law strictly prohibits planned communities from prohibiting the installation or use of a solar energy device. However, planned community associations can adopt rules regarding the placement of these devices so long as these rules do not effectively prohibit the installation, impair the device's ability to function, or adversely affect the cost of the device. Planned communities and condominiums pursuant to ARS 439, like an association's documents, cannot effectively prohibit the use or installation of any solar energy device. So solar energy devices, this is typically the way that this will come up. It's more likely than not going to be in a planned community where an owner wants to put solar energy device typically on their roof, maybe to heat their pool or maybe for a water heater for their home. And oftentimes it's a result of a solar energy company is coming into your neighborhood. Maybe another owner has hired them. And now there's a flyer going to every owner in your association talking about the benefits of solar energy and some tax benefits from installing solar energy. And so what we typically will see is an influx. If there's one, there's usually 5 because of that. And so just from a board's perspective, you have to be really careful on how you handle these requests, architectural requests to install solar energy devices on a person's property or on their roof. First, I'd just like to say it's almost impossible for associations to deny one of these requests. Based upon the way that the laws are written and based upon case law, there's a case called Garden Lakes versus Speaks, which is a case that went up to the Court of Appeals. I actually was one of the attorneys that assisted with that case. The bottom line here is that if you have a homeowner that wants to install solar energy devices, we cannot effectively prohibit them from doing that. And so we can maybe talk about placement locations. We can maybe talk about the number of panels with them, but we need to bring in an expert, a solar expert, to give us advice if we're going to try to deny the application or try to in any way change what they're proposing to put on their property. Because there are the statute that says that, hey, we can't effectively prevent the installation. We can't impair the device's ability to function, and we can't make the cost, adversely increase the cost of installing it. And that's a really tough standard. For the most part, most of these applications are going to be approved by your board. A question comes up sometimes about condominiums, and can an owner put it on their roof if they don't own the roof? And that's actually a really great question. So if you're a condominium or you have a homeowner who wants to put it on your roof, some issues that may come up is it going to void the warranty? What happens when they sell? Who's going to take care of that? If it's on our property, all of these are really good issues. Most of the time, it is not. Most associations do not allow that are condominiums because it's not the owner's property. But we look at them on a case-by-case basis. Some associations have allowed it, and they do an agreement in writing that's recorded so that any future owner is subject to it. And the roof warranty is always a big issue, and that needs to be discussed and managed by the owner and the association as well in a condo. Okay, let's talk a little bit about the third subject, which is mail-in ballots, absentee ballots, and online voting. So we have a great blog that we have written on online voting that we're going to be sharing with you that's kind of more of a deep dive. But many years ago, Arizona law was changed and proxy voting is no longer allowed in like your annual meetings or special meetings of the membership unless you're under developer control. And 99% of our clients are past developer control, and they are having their annual meetings or special meetings of the membership, and they are using absentee ballots or mail-in ballots to vote on issues. So what would be an example? That you would use a ballot for your annual meeting every year to elect directors, or a ballot to vote on a special assessment, or a ballot to remove a director, from the association. And so these are all meetings of the membership type things. And Arizona law allows us to use the absentee or mail-in ballot. Arizona law also allows us to use online voting. And I would say probably like 25% of our associations that we represent now are using online voting. And basically what's happening is there's a statute in Arizona that allows the use of online voting for Arizona HOAs and condominiums. And the association hires a company and they handle the entire voting process online. Owners are given either a password or a number, and they go in and vote using that password number. The owners still can ask for a paper ballot if they want that, or they can also get a ballot at the meeting, because Arizona law does require that at any meeting of the membership, annual meeting, special meeting of the membership, that owners should be allowed to vote by absentee or mail-in ballot or in person at that meeting. So a trend here, I would say, definitely is online voting is becoming more popular. I think it's definitely something that's going to occur more in the future. There are going to be some people that don't like it and don't want to do it, and that's totally okay. The workaround on that is that you give them an opportunity to request a ballot from either your management company or from your office, if you have an office on property, or your attorney, if they don't want to do the online voting, or they can attend the meeting in person and get a paper ballot at the meeting and vote in person. Okay, there are some requirements for mail-in and absentee ballots, and you can look at those specifically on our cheat sheet that we have that we're going to be providing to you, and you can also look at them online under Arizona law if you're a planned community at 33-1812, or if you're a condo, 33-1250. One word of caution: if you are voting on something, let's say you're self-managed, and you're voting on something that's going to be kind of important for your association, like a special assessment, a large special assessment, or maybe a removal meeting of your directors, it would be best practices to be sure to run by your attorney the ballot to make sure that it's fully complying with the statute, because like the specific requirements of the ballot are that it has to set forth each proposed action that you're going to be voting on. It has to provide an opportunity to vote for or against each action. It's only valid for that particular election or meeting of the members. And it has to specify like when the ballot has to be returned by and how it can be returned. And there are some special requirements that like we have to give them at least 7 days after the board delivers to vote the ballot. Best practices would give them a lot more time than that. And then the ballot should specify how many ballots need to be returned to get a quorum, what percentage of approval is needed to approve the action, other than for the election of a director. So there are some kind of specific things. Another requirement is that the ballot must contain the name, address, and signature of the owner. And the ballot cannot authorize another person to cast votes on behalf of the member. And the votes cast by ballot are valid for the purposes of a quorum. So there are kind of a lot of requirements for the ballot. One of the things, kind of like a practice pointer that from being in the industry for so many years, one other thing you might want to add to your ballots when you're doing your annual meeting ballot or a high participation vote ballot, ask for their emails and ask that they can be used to communicate with them in the future. It's a great way to collect information from all owners so that if we need to push things out quickly in the future, notifications, etc., we're updating with current email addresses for the owners. Okay, let's go to number 4, which is annual audit. This is something that there's a lot of confusion in our industry about what is required for HOAs and condominiums to do each year to comply with Arizona law. So let's just talk a little bit about what the law says. So if you're a planned community, it's ARS 33-1810. If you're a condominium, it's 33-1243. It's the statute numbers. And so bottom line is a board of directors and an HOA, planned community, or a condominium is required to conduct an annual financial audit, review, or compilation of the association's books every year. So it's annual. The annual audit, review, or compilation must be completed no later than 180 days or 6 months after the end of each fiscal year and made available upon request to the members within 30 days of its completion. If the association's documents require an audit to be done by a CPA, then the association must hire a CPA to conduct the audit. Otherwise, the association can hire an accountant or have the books reviewed by a committee or a bookkeeper or by maybe a member of the board, maybe even the management company, to comply with the requirement of the annual audit under this law. Now, this is what I'm going to call an imperfect law, because I think the intent of it was to provide for accountability on the finances in an association. But they didn't make, when the legislature passed this many years ago, they really didn't put any teeth in it, because unless your documents, and typically it's going to be in your bylaws, require you to have a CPA, a certified public accountant, do the audit, really anybody else can do it. So it could be the treasurer, the management company, a bookkeeper, an accountant. And we want to be mindful of the reason that this law probably went into effect is because there is a lot of fraud and financial impropriety that has occurred in our industry over the past 30 years. And so the intent of the law was, we're going to try to get a review of the records every year, and that owners will be allowed to take a look at it if they want to, give them 6 months to do it, and then 30 days after the audit is completed, the owners can have a copy of it. But the reality is that most associations do not have a requirement that a CPA do an audit of your books and records. It's very expensive to do this. It's somewhere between $2,000 and $5,000, depending on the size of your association. And most associations are just clicking a box saying, the records have been reviewed by the treasurer every month, and this complies with the audit, review, or compilation under this law. So it doesn't have a lot of teeth. I think if the intent of it was good, if you're one of those associations that has a requirement to have the audit done by a CPA, you definitely need to be on top of that and get that paperwork to the CPA like the first or second week in January, because it does typically take a long time for them to put that together. But it falls kind of like right in the regular tax season, when CPAs are typically very, very busy. So you want to be one of the first HOAs or condos in to get that audit on their books for the year so that you meet that 6 months requirement. Is there any penalty if you don't meet the 6 month requirement? I've never seen a lawsuit on it. And frankly, I go to a lot of board meetings, and even my association included, where we've had times where we didn't get the audit back from the CPA until like October of the following year. So it's just something that we learn from that. And then the next year we say, we've got to get the records to them in January so that, this can be done within the 6 month requirement under Arizona law. Okay, let's switch to number 5. Let's talk a little bit about rental properties for a minute. And this is a hot topic in Arizona, of course, because we are in the Sun Belt, and this is a popular destination for people to move to and people to come to on a short-term basis. So let's talk a little bit about what does the law say in Arizona about rental properties and how HOAs and condominiums handle rental properties. So pursuant to the Planned Communities Act, which is Arizona Revised Statutes 33, 1816-01, and the Condo Act, which is ARS 33, 1260-01, a unit owner or member may use the unit or member owner's or member's property as a rental property unless it's specifically prohibited in the declaration. And they have to use it in accordance with any rental time period restrictions that are listed in the declaration. So kind of the bottom line on this is if your documents are silent about whether or not an owner can rent their property, and it really needs to be in the CC&Rs because it's a use restriction, that means owners can rent their property. So if documents are silent about whether or not an owner can rent, that means that it's not prohibited and the owner can rent their property. If the documents, specifically the CC&Rs, have like a minimum time period rental restriction in there, like you can do rentals, but they have to be a minimum of 30 days or 60 days or 6 months or 1 year, that's okay, but it has to be in the CC&Rs. So a common question that I get is, okay, we want to prohibit rentals in our community. Well, it needs to be in your CC&Rs. That is a provision that needs to be in your CC&Rs. And the reality of this situation is, if you live in a community right now that does not have that rental provision, like a prohibition against rentals or maybe a minimum rental period, it can be difficult to get the owners to approve it after the fact because there's probably owners already that are renting their property and they don't want to lose that right. And there's an important case called the Mulcahy case, which makes it very difficult for certain associations to impose these type of restrictions. So definitely you want to reach out to our firm if you're an association thinking about implementing a rental prohibition or rental restrictions, minimum time periods, and we can help guide you through that process so that you follow Arizona law and Arizona case law to make sure that you're in full compliance and that if it's challenged, you prevail. Okay, next question is one more thing on rental properties. And I just want to mention just kind of a little side thing. If you have rental properties in your community, you can only ask for certain things from the landlord owner regarding the tenant. And the Arizona law is very strict on this. So a very common question that I get is, can we do like a surcharge for rental properties? Can we make the owner pay $500 for every new rental? Really, you cannot do that. Arizona law is very clear. We can only ask for certain categories of information, and that's going to be like the length of the lease, the names and vehicle descriptions of the individuals that are going to be living in the property that are over 18 years of age. And if you're 55 and over community, proof of the fact that one of the residents is age 55 or over, typically it's going to be like a government issued ID. And to ask for all that information, we cannot ask for a copy of the lease. We are prohibited from making that mandatory. We can't make them fill out some detailed rental form, with more information about the renter. It's prohibited under the law. And we're maxed out at charging $25 for each change in tenancy. And if they fail to provide the information that we just discussed, we can charge an additional $15 late fee for not providing us with that information. So we're really kind of, restricted in the type of information that we can request from owners who are also landlords regarding their tenancies. Okay, let's talk a little bit about our next topic. This is a good juicy one: removal of directors and board members from office. Now, I want to distinguish this from removal of officers. So let's give an example. I'm currently on my board and I am a director at large, and I'm also the vice president of my association. And so let's say that my board doesn't want me being the vice president anymore. They don't think I'm doing a good job. 99.999% of the time, I can be stripped of my officer position, my position as vice president, by just a vote of my board, my 5-person board. 3 out of the 5 board members can oust me as the VP of my association. And that is how most associations bylaws allow us to remove an officer from their officer position. If that happens, I'm still a director at large for my association. I cannot be removed as a director at large from my association unless Arizona law is complied with. And that law is ARS 33-1813 for planned communities and 33-1243 for condominiums. Now, this process to remove a director from office it's not easy. And we have been through hundreds, if not thousands of them in the past 29 years. And so we have a lot of good tips if your association is in this predicament right now where you're being notified that there's a petition circulating to remove a director or directors or your entire boards from office. That's definitely a time that you want to reach out to our firm to give you some advice, because we have been very successful in helping associations successfully navigate that situation, whether it's opening up transparency, lines of communication, having a town hall to discuss whatever issues are upsetting the owners, that's prompting them to circulate a removal petition, to pumping out information about what's going on and communicating better. So if you're hearing that, hey, there's a petition for removal of directors in your office, that's time in your association, that is the time to reach out to our office. Okay, let's talk a little bit about the procedure. It's dictated by Arizona law, so it trumps anything that might be in your bylaws or your CC&Rs. So if your CC&Rs or bylaws say something, doesn't matter. State law trumps that, and you would need to follow state law for this entire process. Okay, so first things first. If the board member is appointed by the developer, this law does not apply to, the removal of the developer appointed board member. Okay, so that's an important distinction. It doesn't come up very often, but just mentioning that. So what is the procedure that we follow when there is a removal petition in your community to remove a director, multiple directors, or the entire board? So it depends on how large your association. If your association has 1,000 or fewer members, a petition must be presented to the board for the removal of a director that is signed by the number of persons who are eligible to cast at least 25% of the votes in the association, or 100 votes in the association, whichever is less. So if you have 1,000 or fewer members, typically what we see is, a petition signed by 25% of the members, or 100 votes, whatever is less. It's either or. If you have over 1,000 members, a petition must be presented to the board for removal of a director that is signed by the number of persons who are eligible to cast at least 10% of the votes in the association, or 1,000 votes in the association, whichever is less. Typically, it's going to be the 10%. It's going to be less in those larger associations. So what does the board do when we get a petition? Usually it is kind of a high stress situation. So we receive the petition, and you should be reaching out to your attorney immediately to discuss it. This is not something that you just put on the side of your desk, and here's why. Because state law is very clear. We only have 30 days from the date that petition is submitted to conduct a meeting of the membership to vote on whether or not the director or directors should be removed from office. So this is like expedited time frame. This is like, annual meeting prep on steroids, right? So as soon as we get that petition, reach out to your attorney. What typically happens is we will start going through the petition line by line, and we'll be verifying that a record owner signed the petition, that there are no duplicates. So sometimes the husband signs it, the wife signs it, and there's duplicate signatures. We also will verify whether or not the person who signed it is delinquent in any way in payment of the assessments or fines or any other manner to the association. And how we can do that is it says that it's eligible to cast. So the owners that are eligible to cast their signatures, those are the only ones that are allowed to be counted for the petition. So after we go through the petition, let's say they don't have the votes that they needed based upon the size of their association. Well, then we write a letter back to everyone who's on the petition, or we do a communication to the entire membership saying, hey, they didn't have the requisite number of votes, and so this petition is not moving forward. 95% of the time when we get these petitions, though, the people that are doing it are very organized, and they add, some extra wiggle room in there. More likely than not, they're going to have extra names in there, knowing that some names are going to be thrown out for delinquencies or not being the record owner. And so 95% of the time, these petitions really do move forward. So I would say probably it takes 2 to 3 days to verify those signatures, business days, and to verify that they're owners and that they are not delinquent or owe money to the association. Another question that we typically get at this stage is board members think that the signatures were forged, or board members think that the person didn't really sign it, or that they didn't understand what they were signing. A very common thing that comes up in this removal petition process. Really, we have 30 days, right, to get this done. And so it is really complicated to try to contact the people and say, is this your signature? Did you understand what you were signing? And so really what we will do, if that is an issue or the board's raising that issue, is we'll send a letter by email or quick delivery to all the people that signed it saying, we received your name on this petition and your signature. If you didn't sign it, please notify us immediately. Or if you didn't understand what you were signing, you want to withdraw your name, please contact us immediately, give them an email address. Occasionally we get 1 or 2 on that, but more likely than not, these people did sign it and they understood what they were signing. Okay, so now let's move forward to the special meeting. So we now are in planning stage because we know that they had the requisite percentage on the petition to have the meeting. And so now we are very anxiously moving forward aggressively moving forward with planning the meeting. So we need to find a venue for the meeting. We need to do a ballot. Typically, the board members that are being removed want to write a letter to the community, and they want that included with the ballot with regard to their position about, why they shouldn't be removed. And typically there's like a notice, obviously, that goes out with that too. So we've got the notice of the meeting, just a single piece of paper saying date, place, time, purpose of the meeting. And then we've got the ballot, which your attorney should help you write. And then maybe the board members that are being removed have a statement that they want included with the mailing. We have to mail that at least 10 days or not less than 10 days before the meeting, and not more than 50, but it's really going to be like 30 because we're in this 30-day window. So we've got to get that ballot out quickly. Maybe you're using an online voting company like we talked about a few minutes ago. Maybe you're using paper ballots, but all of those need to be within that same first week that you got the petition. Now we're on probably like day 6 or 7. You should be mailing out the meeting notice, the statement from the directors that they want to do so on the ballot. By day 7, I would say would be a good goal. And then we get to the meeting, the night of the meeting. So the night of the meeting or the day of the meeting, there has to be a quorum at the meeting. So we open the meeting, and the quorum at that meeting is 20% of the votes, or 1,000 votes, whichever is less, must be present in person or by mail-in or absentee ballot. In my experience from attending a lot of these meetings, I can tell you that this is the social event of the year for your association. And I think only one time in my entire career, 29 years, have I had a meeting not have a quorum for a removal meeting. So, like I said, it's a social event of the year. So people, they show up, they vote. And so getting a quorum is typically not a problem. But we start the meeting, we establish the quorum, and then we count the ballots. Oftentimes we'll be counting the ballots as they come in. I have them on an Excel spreadsheet with each vote by each person to make sure that there aren't any duplicates, etc. And at that meeting, a member of the board can be removed with or without cause. So you don't have to have cause. You can just be removed because you don't like them, or don't like their bedside manner, or whatever, don't like how they're handling the new pool renovation or whatever, by a majority vote of the members eligible to vote who are voting on the matter at a meeting of the members called for the removal purpose. And so basically, like, let's give an example. Let's say that you have 100 members show up in person or by mail-in or absentee ballot. You would need to have a majority vote. So 51 out of the 100 would have to vote to remove the the director from office. You're going to look at it for each director that's up for removal. So get removed and the other two survive it. It just depends. My time is because why? Because they just want to get your attention and tell you, hey, we're not happy about how you're handling this renovation, or we're not happy that you're not communicating with us, or whatever. They want to get your attention. The homeowners do, but they don't really want your job, right? Because let's be real here. Being on a board is a lot of work. It's a volunteer position, and you can never keep everybody happy. So it's kind of a high stress volunteer job. And so my experience is that probably 80% of the time the board survives the recall. And, they learn from it. It's painful to go through this process, but they learn from it and they try to do better going forward. One thing I didn't mention that I think I probably should is that sometimes a board gets a removal petition and the board members that maybe has their name listed on the removal petition, they just decide, I'm done. I quit. And that's okay. That happens time. And just make sure that that person, if they decide they're going to quit before the removal meeting, that they put the resignation in writing and that we notify the community that person has resigned from the board prior to the removal meeting. A couple important things just to know about this meeting after it occurs. So you have to keep the documents for at least 1 year from the meeting. So you got to keep the ballots, the notice of the meeting, anything that's in writing, the petition, everything needs to be kept for at least 1 year. And if any owner wants to inspect them, we're going to be talking about inspection rights in a few minutes here, but we are required to allow them to inspect the records from that meeting. There's only one removal attempt per term. So I always laugh and say, if you survive the removal attempt and they don't get the votes to remove you at the removal meeting, guess what? They cannot try again for the rest of your term. So if you're elected for a 3-year term and they try to remove you in the first year of your term, you're home free for the next 2 years. They cannot remove you. What do we do if somebody's removed, right? So now we're at the meeting and maybe, let's give some examples. Maybe one director is removed, but fewer than a majority of the members of the board are removed. The vacancies shall be filled as is described in the association's documents. So if only one person and it's less than a majority, then we go to what do the documents say? Most of the documents are going to say that the remaining board members will appoint the people that are going to replace the removed directors. But if you have a majority of the directors that are removed at that removal meeting, and if the association's documents don't provide a method of filling the board vacancies, if it's just less than a majority of the directors are removed, then the association has to hold an election for the replacement of the removed directors at a separate meeting of the members of the association. And that has to be held not later than 30 days after the meeting at which the members of the board of directors were removed. So if you have a situation where your documents are silent, which I would say that's pretty rare, usually the board can appoint people to fill vacancies, but if a majority of your board is removed, then you have to have a special election and you got to do that again in that expedited 30-day timeline. So this entire process is stressful, expensive, and we really encourage boards and homeowners to think about whether this is a good thing for your community, because it is expensive and stressful and it's divisive to communities. Be better to sit down and talk through your issues. Okay, let's talk a little bit about display of flags. And a brief mention of political signs. So we're going to just spend a brief amount of time on these last 3 or 4 topics. This is number 7. So there are, just so you're aware, there are a number of flags under Arizona law that the association, a condo, or an HOA cannot prohibit the display of these flags. So it doesn't matter what your documents say, this is going to control. So anytime that an owner wants to display an American flag, or an official replica of a flag of the Uniformed Services of the United States, as long as those flags are being flown consistent with the federal flag code, the association cannot prohibit that. The association can't also not prohibit the following flags: the Arizona state flag, the Arizona Indian Nations flag, the Gadsden flag, a first responder flag, and a first responder flag can incorporate the design of 1 or 2 other first responder flags to form a combined flag. The Blue Star Service flag or the Gold Star Service flag These are military flags that represent a family member actively serving in the military, or a family member that died while serving in the armed forces. And last but not least, any historic version of the American flag, including the Betsy Ross flag, without regard to how the stars and stripes are arranged on the flag. Associations, must adopt reasonable rules and regulations regarding the placement and manner of display of the flags. And they may also regulate the location and size of flagpoles, but cannot prohibit the installing a flagpole in a planned community. Also, the HOA can limit no more than 2 flags at once, and may limit the height of the flagpole to not more than the height of the rooftop of the owner's home in a planned community. Okay, we have a new law change that went into effect this year, and this is kind of a sign of the times law, I would say. But if somebody is flying a political flag, that is okay. Political signs are included in, are allowed to be flown, but you have to follow the restrictions under Arizona law for political signs. And that's going to be, you can only put them up a certain number of days before and a certain number of days after, and it has to be a certain dimensions. Also, a brief mention of for sale and for lease signs. Those are allowable on an owner's property under Arizona law as well. There are some restrictions on that, but you can look at our cheat sheet on that, or you can look up the statute, which talks about flags and signs in one very long statute. And that is going to be 33-1808 for planned communities and 33-1261 for condominiums. Okay, let's go on to number 8, which is fines and penalties. So we use fines and penalties in an association context to deal with owners that aren't following the association's documents. So they're violating, maybe they install something on their property without getting approval, or maybe they're not maintaining their landscaping. So here's just a quick 411 on how boards can effectively use fines and penalties. An association or a board can impose a reasonable monetary penalty for violations of the declaration, the bylaws, or the rules. They have to give notice and an opportunity to be heard before they can levy that fine or penalty. So bottom line is, number 1, an owner has to be violating something in the CC&Rs, the bylaws, or the rules. Okay, then the association can send a letter to the owner. They have to set it up. We've noticed they have been putting your trash cans away on the days that you're supposed to, and they're left in the street for all week. And then you have to give notice of the violation, an opportunity to be heard. So we like you to respond in writing by email to the manager, to this board member within 10 days of receipt of this, or 5 days, or 3 days, or whatever you decide. And then after that, the third step in the process is then you can levy the penalty if you choose to do so. So it's kind of a 3-step process, and it's most of the time associations are doing it properly, but just don't forget that it's 3 steps. You can't just send a letter out saying, we saw that you left your trash can out for a week and now we're giving you a $100 fine. Another thing to remember is the fine has to be reasonable under state law. So remember, as an attorney that practices in this area, I have to go argue in front of a judge that a fine is reasonable. And I've had situations where the judge will say, like, hey, I don't think $1,000 for not trimming a palm tree is reasonable because it would have only cost $300 to trim it, and so we've got to be really practical and reasonable, knowing that in order to collect on this fine or penalty, we have to go to court and get a judgment and have a judge rule that this owner owes the association for this fine or penalty amount. And so there's a 4th process, really. Then you've got to get a judgment against the owner in order to collect it. Okay, let's go to the next one. Number 9, dealing with difficult people. I changed this one out this morning when I was preparing for the class because I just think it's a really important topic for associations. So I want to spend a couple of minutes talking about it. Probably the worst part of being on a board, in my opinion, is dealing with difficult people, homeowners, tenants, maybe. And so I want to just take a few minutes and talk a little bit about what are some strategies for dealing with difficult people, and what are the legal remedies that you may have if this person is dangerous? Because unfortunately, we have seen an increase in the number of situations and associations where somebody's like right on the edge of, hey, now we're getting scared of this person. They're doing strange things, they're making threats, etc. Okay, so let's just talk about the run-of-the-mill difficult owner, right? We call them gadflies typically. They like to come to the meeting and tell us that everything's horrible in the association. They make personal attacks against the board members. They claim we're stealing money. They argue just to argue. They make serving on the board unpleasant. Let's put it like that. So how do we respond when we get one of those people who comes to the meeting or maybe who's writing poison pen letters to the board or the community? Really, the most important thing is stay calm and rational when dealing with somebody like this. If we get a one-on-one with them, ask the person to explain the exact issue so we can better understand what's going on and deal with each issue one at a time, because usually they have 5 or 6 things they're upset about, in order to let them know that, hey, we're listening and we want to understand why you're so upset. If there's anything that they say that we agree with, say it. Like if they say, hey, we called the management company and they never called me back, apologize and say, we are very sorry for that if that did occur. And we are going to be talking with the management company about making sure that they respond to every owner within 48 hours or whatever the protocol is that we've said. Sometimes when they come at you really upset about things, sometimes you just need to take a deep breath and not resist the urge to argue. Compose yourself. Just say, thank you so much for coming here today. We understand your frustrations and we are going to do everything we can to try to address this issue. Come back to next month's meeting and you'll see that we're working on a few of these issues. Tell them, hey, I'm sorry that you're angry about this. We can do better if we've made a mistake, or we're working on this. Maybe we need to communicate better so that the homeowners know that we are working on this issue, or thank you so much for bringing it to our attention. Like, we didn't realize that this was such a serious issue and now it's on our radar. We're going to deal with it. Resist the urge to fight. Resist the urge to raise your voice, to respond back to them if they're escalating it. Just listen, give them a moderated tone back. Thank you so much for being here. Why don't you stay after the meeting so that we can talk more? These are all good suggestions to handle it. Now, what do we do if it turns into like actual harassment where they're making threats? Under Arizona law, we have a great procedure to get an injunction prohibiting harassment against an owner or a tenant, but there has to be like a threat of harm, or there has to be actual harm to whoever the person is that's asking for it. So it's a remedy that you need to keep in your back pocket if you feel that you are being threatened and there's evidence of at least 2 times that you've been threatened by this owner or homeowner or tenant. Then you definitely need to be reaching out to legal counsel to talk about, can we go to justice court to get this injunction prohibiting harassment? Will be successful. Okay, let's talk about our last subject, number 10, inspection of records by members. So at some point on your time on the board, you're going to have an owner who is going to want to see the books and records of the association. And that is totally okay. I mean, we're volunteers. We want to be transparent. They basically can see everything except for a few small areas. So how we typically see this come in is an owner's upset about something else. Maybe they got a violation letter. And now they want to see if everybody else got a violation letter regarding the same thing. So they are asking for a lot of different records. Just so you know what the law is, basically they can see pretty much everything. And we're going to go through the things they can't see in a second, but we have 10 business days to provide the records to them, and we can charge them 15 cents per page for any copies that we make. The records that they cannot see are going to be privileged communication between an attorney for the association and the association, pending litigation, meeting minutes from executive sessions, personal health or financial records of an individual member of the association, individual employee of the association, or an individual employee of a contractor of the association. And then last 5 is records relating to the job performance of, compensation of, health records of, or specific complaints against an individual employee of the association or an individual employee of a contractor for the association who works under the direction of the association. So kind of my feeling on records requests is just give them what they want. If we try to play hide the ball or we're not giving them the documents they want, it's honestly going to snowball and make things a lot worse. So if someone's asking for a lot of documents, what I'll typically do is I will pick up the phone and call them and ask them some questions. Hey, I'm Beth Mulcahy. I'm the attorney for the association. I saw this records request for records for the past 10 years. And I want to just find out more, like, what are you concerned about? And what records can I help you locate that are going to help you find the answer to that? And oftentimes after that phone call, it's whittled down to like 5 pages. So really think about using your legal counsel to help you to manage the situation. If it's a large records request, if it's a small records request, just push it out to them by email. I wouldn't even charge the 15 cents because you're not making a copy. And just recognize, hey, we're not hiding anything. This is everybody's community. There's some things you can't have, which are going to be like legal opinions, or if we're involved in litigation with somebody, those are like a no-brainer. We're not going to give you somebody's social security number and a private cell phone number as an owner in the association. But pretty much everything else is fair game. And so it's important for you to know this is a requirement under the law, and it's a great thing for transparency. It only typically comes up, unfortunately, when an owner is upset about something else. But it's an opportunity to turn that person around. If you pick up the phone, call them and work it out, it could be an opportunity for a win for everybody. Okay, we finished our top 10. Let's briefly close it out with our secrets of successful associations. So I have 29 years under my belt, and I've seen a lot of different situations in 29 years involving associations. So we have a cheat sheet on secrets, which is going to do kind of more of a deep dive. But I have a few things that I'd like to share with you that I think are some small secrets that can really make a difference for your association on being successful. So number one, the associations that communicate the best with their owners have the fewest problems. So be good communicators. Keep people informed about what's going on. Make sure that you're posting your open meeting notices 48 hours in advance. Encourage people to come. Have a newsletter. Use social media to inform members of your community about what's going on. Our cheat sheet gives you some more specific examples on good communication, but just really, truly, the most important thing for boards to know is if you're communicating with your owners, you're going to have a heck of a lot less hassles. Okay, number two, have strong leadership in community associations. So your board members, they need to be good leaders. And how do you be a good leader? You listen. You follow the rules yourself. You're honest. You have integrity. You're transparent. You're a good team member, meaning you're not letting everything fall on one person on the board and everybody's kind of carrying their own weight. You have a commitment to the cause. Now, I'm going to be honest with you. I've been on my board, and there have been times where I've thought, I'm so sick of this. I really just want to, I'm not a quitter, but I really just want to gracefully exit. But I always come back, because it's important to have strong leaders in your community. And I don't want my association to decline. And so I think that you have to have people who are strong enough to take a little heat and who have a sense of humor. And that's very important. We're on the board. You have to be able to laugh because some situations just require that to survive. And you just have to be determined. Okay, I'm on this. I'm not going to be friends with everybody. There are going to be some people that don't love painting the new common area. I'm determined to do what's right and you got to follow the law. You got to follow Arizona law. You've got to follow your association's documents. Going to classes like this is a really great first step, but also having trusted advisors that you can lean on when you're not sure about problems in your community. So trusted advisors are going to be your attorney, your management company, your reserve specialist, your CPA, your landscaper, your pool company. All of these things are your trusted advisors, and you're not expected to know everything being on the board. So you want to have a successful association, have a good relationship with your trusted advisors. Your insurance agent is one I forgot. All of these people are here to support you and help you make good decisions. So that's the end of our presentation for today. We're going to now go into our questions. Sorry, I'm going into a little bit of overtime, but this is kind of a hard class to teach because I didn't want to leave anything out. So about 9 minutes over. So I apologize for that. We have 37 questions, and I'm just going to start right with the questions. Question number one, if the board deems email to be a reasonable method of providing notice for a board meeting, then can notices just be emailed to the owners? So yes, if you have everybody's email, that's fine. If you don't have everybody's email, then you may want to put it on your website too, just to make sure you get everybody has notice. Question two, our HOA board meets an executive session both before and after the open meeting. The meeting notice always lists all 5 statutory reasons, regardless of topic, and the open meeting minutes do not note that an executive session occurred or cite the statutory reason. The management company says this is not required. Is this correct? Also, the board does not include an open forum for homeowner comments Attendance is low, 3 to 5 owners come, but is the board still required to provide an open forum? Okay, this is a lot of questions, but I'll condense them quickly. Okay, so when you go into executive session, you just have to list either in the notice or the agenda or before the executive session starts, the topics that you're going to be discussing that are executive session topics. So it sounds to me like your association, the meeting notice lists all 5. They probably do that just as a box checker to make sure that they cover everything in case something comes up at the last minute. So your board's doing that correctly. The board does not have a homeowner forum in the open meeting. You're not really required to under the law. So homeowner forum is typically done at the beginning of an open board meeting and allows owners to say whatever they want to say for a minute or two about things that are going on in your association. You're not required to do that. I think best practices are that you do it, but you're not required to do that. But the board is required before the board takes formal action on anything to open up to anybody that wants to talk that's not a board member, just a homeowner. And they are required to give them a minute or two to comment on anything before the board takes formal action on anything. Anytime the board's taking a vote is going to be a really good example of that. Okay, question number 3. The recent storm damage is causing our HOA to need to assess our residents $500 each, but our CC&Rs require a ballot to approve it first. Is there anything in Arizona law prohibiting the HOA from collecting the $500 ahead of time from residents who wish to pay now instead of waiting so that we can get this damage cleaned up right away? So I don't have an issue with that. If owners are gratuitously just going to make the payment to help us get this moving, I'm fine with that. Okay, question number 4. We have some members who want to go to a desert landscaping to get rid of their grass. They want to hire unlicensed, uninsured, cheap contractors. Our CC&Rs require them to submit an architectural change request before any work can commence. In evaluating their plan for the ambiance of the HOA and approving it, are we accepting any liability? So this is kind of a loaded question. You have to look at what your documents say about architectural approvals, and you have to evaluate the application based upon that. What you might want to do is you might want to put as part of the approval that licensed, bonded, and insured contractors must be used. And prior to beginning the work on this project, you need to provide us with your contractor's name, license number, and that information so that we're ensured that this is being done. I mean, best practices always is going to be use licensed and bonded and insured contractors, especially if they're doing irrigation. They are required to be licensed, bonded, and insured with the Arizona Register of Contractors. So you may want to contact the Register of Contractors if they're not doing that. Make a complaint against whoever they have out there working. Okay, question number 5. As an HOA board member, I submitted a records request for copies of CC&R violation letters sent to homeowners this year. Property manager refused, stating a board vote is needed and offered only a summary report. Am I legally entitled to receive copies of these violation letters as an individual board member without needing the rest of the board to vote or request them? So my feeling is you are entitled to receive that information and your manager should give it to you. It kind of raises a red flag to me, like you're a board member. You have access to everything. And so to require a vote of the board to give that to you seems like they are trying to prohibit you from getting it, make it difficult for you to get it, which I don't think is a good trend. Now, if it has to do with you or something, and this is your personal issue, then, maybe we need to look at this a little differently, because if you're thinking about suing the association because of a violation letter you got, you want to use the information that you have as a board member for your personal use, that could be a little bit problematic. So I want to just throw that out there and say that if that's the case, then maybe the manager and you need to have a discussion with me and we can talk that through. Okay, question number 6 from an owner. A homeowner, investment property owner, or realtor in a planned community did not follow the governing documents, rules, and regulations and has outstanding fines and violations on the property's account, and the home is now listed for sale. With respect to violations, the homeowner had the opportunity to be heard and afford themselves that opportunity and have received response to the appeal. Are they obligated as a realtor owner to tell all prospective buyers that the property has fines levied against it and modifications to the home that were not approved by the association? I mean, this is kind of a question that probably needs to go to the Department of Real Estate, but I mean, my feeling is if the realtor has knowledge, they should be notifying the other realtor that's on the other side of the deal or anybody that they're bringing in to look at the property that there's an issue with the violations on this property that need to be addressed before the close of escrow. Okay, question number 7. Our HOA used possible fee increases that were not used in previous years to calculate an increase larger than the CPI. Is this legal? I'm never in favor of doing that. I know that there are some law firms in Arizona that will say that if your documents allow the board to raise the assessment 10% every year, they exercise that right in the minutes, but then they don't collect it. And then at the end of 3 years, after doing that for 2 years, they try to raise it 20% based upon the prior years without a vote of membership. It hasn't been tested under the law yet in a court, but I feel that if it was tested, the association would not prevail on that. I don't think it's a good idea. I think the documents are in place for a reason. You increase it in that year or you don't increase it. And I don't think you can reserve it or take advantage of it and then not collect it. I think it's going to not go over well with a judge. And I don't think an association will win if you're challenged on that. Okay, question number 8. If homeowners have recently took over control from the developer and builder, should the new HOA board conduct any due diligence with the management company, association records, bank accounts, negotiate and sign new contracts? What would you recommend they do? Okay, number 1, you need to look at our cheat sheet on transition from developer to homeowner control. Because in that cheat sheet, we list the most common issues that come up in a transition. And I can tell you with absolute certainty, I don't think I've ever seen a transition from developer to homeowner control where there weren't some issues, minor, major, right in between. The second tip I'm going to give you is you really need to reach out to our firm and have just a short meeting, 30 minutes to an hour, and talk through the issues. Remember that the management company is often aligned with the former developers. You want to be mindful of what you're saying to them. And you want to be mindful of any advice they may be giving you because they're going to get other properties from the developer and they probably are trying to keep the peace and don't want the developer to get sued or have conflicts. And so you have to recognize they may have a competing interest and may not be giving you impartial advice or comments on things. So really recommend that you reach out to our firm. We can have a short meeting with you and talk it through and see if you need to investigate anything further, and check out our cheat sheet too. Question number 9. Is there a difference between a board director and an officer? Can a board appoint an officer to assist but not to vote? What's the title and is there a resource to define this? We have a great cheat sheet called What is an Association? It's on our website at mulcahylawfirm.com that talks a little bit about the different roles of board members and the difference between a board member at large and an officer that I would really encourage you to take a look at. Whether or not a board can appoint somebody like typically an officer saying, but they don't vote, that's pretty unusual and it would have to be in your bylaws to allow you to do that. Okay, question 10. Is there a standard percentage to pay a property management company, especially based on owner fees and amount in a reserve? No, there really is not a standard percentage. I mean, way back in the day, 25 years ago, they used to say dollars per door thing, but that's that whole financial side of how much a management company charges an association has really changed over the years. And what we've seen now more likely is that the monthly fee is lower, but then the add-ons on the exhibits to the contract are what generate a lot of income for the management companies. So short answer is there's no standard percentage, but if you are interested in having us look at whatever your contract is with the management company, we can tell you, this is market rate, etc. Okay, question 11. What if board members are related? How do you keep that without suspicion? I don't know what you mean by related. Are they brother, sister, or aunt and niece, or are they husband and wife? I think the best thing to do is to disclose it, be upfront at a meeting, and that can help with the suspicion. I really never like it when a husband and wife are serving on the board at the same time because I think you should try to find independent people. I think it's too much power rested in one household. And so those are some tips on this. Okay, question number 13. When issues arise that require immediate attention, the board communicates by text or email to resolve them. Are there limitations to this form of communication and decision-making? Well, we talked a little bit about under number 1 in this presentation about emergency meetings. It sounds like you're doing an emergency meeting by text or email. Just at the next regularly scheduled board meeting, print out those emails or texts and attach them to the minutes and explain what the emergency was and what the decision was, and that these are going to be attached to the minutes for this meeting. Okay, next question, number 14. We do work sessions to talk about specific contracts, etc., with all board members. Is that subject to the open meeting law? So yes, anytime a quorum of the board is meeting to discuss association business, even if it's a work session, even if you're not voting on anything, it is still an open board meeting and needs to be noticed as such. Okay, question number 15. We have 5 board members. Can 3 of us play golf together or get together for dinner? The concern is invariably HOA business will come up. What can or can't we discuss? So 3 is a quorum. You shouldn't be discussing anything pertaining to the association. If you're playing golf or out for dinner, it's just not proper. Okay, and against the law. Okay, question number 16. Do the same open meeting laws pertain to working sessions by the sub or master committees? Yes, if they're set up as an association, typically that's going to be like a planned community or a condominium. Yes, and it's the same is going to apply. Question number 17. Do the same open meeting laws? Let's see. I think is this the same question? Okay, no. Do the same open meeting laws pertain to committee meetings of committees sanctioned by the board that pertain to board meetings? Oh, this is a good question. I didn't address this in my presentation, so I'm glad you brought this up. So the open meeting law applies to committees and an association that meet regularly. So if you have a committee that is a regularly scheduled committee that meets regularly, they are required to comply with the open meeting law. So if your architectural committee reviews applications the first Friday of every month, that is a regularly scheduled committee meeting, and it would need to be an open meeting. If you meet sporadically without any regular schedule, then you're not required to be subject to the open meeting law as a committee. Question 18, are HOA management staff allowed to run the board meeting? Our board rules is that owners can ask questions about an agenda item, but that is not done in practice. I mean, it's kind of unusual that a management staff would run the meeting. Typically, the president is running the meeting, but sometimes if you have a board that maybe is inexperienced or you have a difficult owner that's causing a lot of problems, sometimes the management company will step in and help out. Are they allowed to run it? I suppose yes, but it's unusual. Next question, number 19. Our board will be making a committee appointment. Can I share my appointment choice with another board member? As long as it's less than a quorum, yes. Number 20, if a regularly scheduled meeting has to be canceled due to unforeseen circumstances, and this happens 3 hours before it starts, how should this be handled? A couple ways. You can blast out notice to your community, and on email or post it on your website. You can have one person on Zoom. So if anybody shows up on Zoom, you can say, sorry, the meeting was canceled. I mean, that's probably more than what most associations would do, but those are some suggestions. Question number 21, do the regularly scheduled every 2 weeks on Google meetings of the architectural committee need to be noticed and open for homeowners' attendance? Yes, because they're regularly scheduled. Question number 22, what is the difference between executive session and a special meeting? Good question. So we've got 3 different meetings here. So we've got an open board meeting, right? It's where we do our normal association business. An executive session is where we only talk about the 5 executive session topics that we talked about earlier in this presentation. And then a special meeting of the board could be an open meeting or it could be an executive session. It just depends on how it's noticed. Maybe the special meeting is in between the monthly meeting to address a special topic. Okay, question number 23. If the meetings are audio and video recorded by the association, is it required to make both audio and video recording available to the community as opposed to just the audio? I mean, I'm assuming that, I guess, short answer would be to be safe, yes. If they want it, if you have both of those recordings, short answer would be to be safe, yes. If they want it, make a request. If you are posting it somewhere, you could probably just post the video because it's also the video and the audio at the same time. Okay, next question, 24. If a condo building in an older condo complex had and possibly still has a rat infestation that left a very large amount of rat feces and urine inside the walls, ceilings, and areas in direct contact where the airflow going into the unit's air's intake system before being recirculated back into living spaces, what should the association be expected to do to handle it, since it is a building-wide issue and not just a per unit issue. Ooh, that's gross and scary. Well, I think that there needs to be, first I would get advice from whoever came in and did the infestation, got that under control, and see what they suggest. You may want to bring in like a special company that deals with, I don't know how serious the infestation was, but you may want to bring in a company to give you some advice about like a hazmat company to see if maybe do some testing in certain areas to see if this is something that does need to be looked into further by your association. I mean, if I were you as a homeowner, I would get an air purifier. If there's a smell, I think you need to document. Maybe you need to bring in your own expert to talk about this with your board, because it probably does need to be treated by the association. Maybe covered by the insurance too, don't know. And so if your association's board is ignoring it because they're worried about the cost, this could be something that could be covered by the association's insurance carrier. Question number 25. We often have a quorum of board conspiring to discuss topics via phone, emails outside of the open meeting, specifically not meeting in person to circumvent the open meeting law, but coordinating and communicating and making collective agreed upon decisions. This group includes the president and vice president of the board. They consistently exclude other board members. Then they vote together as agreed upon at the next open meeting. Are the prior discussions and decision to coordinate a collective vote in violation of the open meeting law? So I don't know what your quorum is, but I'm assuming that 2 is less than a quorum, and this is okay under the statute. So, if 2 board members is less than a quorum, they can talk about issues. They can decide how they want to vote on issues. It's not a violation of the open meeting law. I'm not saying it's a good thing. I'm just saying it's not a violation of the open meeting law. I mean, obviously, as a board, we talked about secrets of successful associations, right? One of the secrets is your team, and intentionally excluding other board members or trying to get, doing things like this could undermine the teamwork aspect of being on your board. Okay, question number 26. We are looking at having a special assessment. How would we handle any homeowners that may refuse to pay the special assessment? This is a really good question. So we have a special blog on special assessments, which we're going to be sharing with you. A couple thoughts. Number one, when you're preparing the budget for the special assessment, like whatever you need it for, you may want to factor in a delinquency percentage that is similar to your regular assessment delinquency percentage. So let's say you have 8% of your owners not paying. You may want to add a 8% to the special assessment amount. So make the special assessment higher by 8% than you normally would, because you're thinking, hey, maybe these people are not also going to pay the special assessment. Another thing that you may want to do is give people payment plans. If you're worried that, hey, they can't make a $2,000 payment all at once, let's give them a payment plan so that they can, pay this over time, and therefore they'll be more likely to pay it. Obviously, if they don't pay it and they don't want to do any special payment plan that you have the same rights that you would have, legal rights, as they weren't paying their regular assessments. You can lien them, file a lawsuit against them, get a judgment against them, potentially foreclose if they meet the threshold for the foreclosure requirements. So lots of different options for your association. Question 27. What if there's never 1/10 of the owners who show up at meetings? We only get 1 to 5 people in 25 years. Well, a couple things. One good thing is that means things are going well. So you don't have a lot of people coming to your meetings, because trust me, the association where things are not going well have, standing room only at their meetings, lots of yelling and screaming. So things must be going well. Well, a couple things that you might want to consider. Our cheat sheet on annual meetings has some great tips on how to increase attendance. Make it a party, have a party in conjunction with it, have it on a Saturday morning, a time that maybe might be better for the residents, plan it in conjunction with an event. There's a number of different suggestions that we have to increase attendance and to try to get a quorum of members at meetings of the membership. If this is just regular meetings that you're talking about, continue to publicize when the regular meetings are and hope that the owners that are interested will come. If they're not coming, though, it usually does mean that they are happy. Okay, question number 28. I was on the board last year and we updated the bylaws. They were not notarized or registered or recorded with the Maricopa County Recorder's Office. The one and only person on the board says that they are not valid and insists on going by old bylaws. is our only avenue to vote him out and be on the board as an only board member since the other owners refuse to be on the board. Okay, lots going on in this question. So when you update your bylaws, just so you know, you do not need to have them notarized and you do not need to record them with the recorder's office. The only thing that you have to do is follow the procedures to amend the bylaws and have the board president and secretary sign the final version of the amended bylaws and put them in the association's records. So the current board member isn't correct on that. You may want to share this video, share these videos on our websites. You could scroll to the section number 28 and have this board member listen to it. And I can say the way the board did it was valid. Is your only avenue to vote him out? If that doesn't work, yes, you can remove him. We talked about the removal process today. You could also hire a lawyer to write him a letter to let him know that, hey, the bylaws are valid. You could file a lawsuit against the association. I'm not encouraging you to do that. You could go to the ADRE, Arizona Department of Real Estate, to have an administrative law judge rule that the bylaws are valid. These are all different suggestions. Write this board member a letter expressing your concerns. Run for the board yourself when the next board meeting's up. Next board election's up. I mean, it's kind of odd that you only have one person on the board, so maybe see if you can get appointed to be on the board. These are all good suggestions. Question number 29. Our association needs to discuss communication from our legal counsel within a short timeline in order to respond to a different attorney's communication to us. We want to have this discussion in executive session. Can we convene an executive session by itself with one topic without it being part of a regular board meeting? So short answer, yes. Or do we need to convene a board meeting or emergency board meeting with one topic and then immediately go to executive session? So good question. You can just notice it as an executive session and go into executive session. If it's an emergency and you can't wait 48 hours, then just do an emergency executive session meeting and then read into the record at the next regular executive session what happened, what the emergency was, and attach the minutes to that next executive session meeting. Question number 30. Can an HOA limit the number of non-related individuals living in a single rental? That's a good question. We've had that many times over the years. It's really difficult to do that. You may want to check with your city, town, or municipality to see if they have any specific restrictions on that you might be able to enforce. Typically, they're unwilling to enforce it, in my experience. I mean, it just depends. Is this like a party house where they've got 30 people living in a 2-bedroom? Then maybe the city will get involved, or maybe the association will get involved because they're creating a nuisance. But is this a family that has multi-generations living under the same roof? I wouldn't get involved in that because I think that could raise some fair housing implications. We don't want to get sued for a violation of the Fair Housing Act. So I think we got to look at that on a case-by-case basis. You're welcome to reach out to me and we can talk more about it. Question number 31. What recourse does a sitting board member have when the other directors make decisions without involving the full 3-member board? Some matters involving individual homeowners are being discussed informally, which seems to violate HOA law and fiduciary responsibilities. So, you only have a 3-member board, so 2 out of the 3 talking about things is a violation of the open meeting law. So I think you just need to raise the issue and say this needs to end. Okay, next question. Let's see. If several members at a board meeting call out the board members' failings, breaking of laws, not following governing documents, and ask for the board members to resign, can any board members that are left appoint anyone to fill the openings of the newly resigned board members? Or should another process be followed? This really is going to be in your bylaws. Typically, the sitting board can appoint new board members. There's always some discussion about, should we throw it out to the community and say, hey, is anybody interested in being on the board? Give us your name and a bio, or can the board just hand select somebody without doing that? There really is no hard and fast rule on that, but typically the bylaws do allow you to do that. Question number 33. ARS states that the board, Arizona Revised Statute states that the board shall allow a member of or a member's designated representative to speak once after the board has discussed a specific agenda item, but before the board takes formal action on that item in addition to other opportunities to speak. Does this mean that owners only have the right to speak on agenda items that are being voted on and not other agenda items that do not require a vote? This is a good question. So my opinion on this is that the board only opens it up for homeowners to comment before the board takes formal action on an item. Now, some boards also will do a homeowner forum, and that's great. I totally love that idea. I think it's a great idea. I do it at our association, or sometimes we have homeowners that come and want to talk. We listen. Great communication to have a successful association. But so to answer your question, I think my interpretation of the law is that you can only, as a homeowner, contribute at a board meeting under the law when the board is going to take formal action on something. So it's an agenda item. The board's going to vote on it. There's a first, a second. Now we go into discussion. That's the time if you're a homeowner and you want to talk about something that you need to raise your hand and say, I would like to make a comment on this. They can put a time limit on it, but you do have a right to speak at that time. You don't have a right to speak on other agenda items if the board is not taking formal action on it, unless the board voluntarily allows you to do that. Okay, question number 34. This is a condensed version. In our condo association of 250 plus units, one family controls the HOA board and management. Family members are both directors and community manager, and together they own about 10% of the units. The board allows the manager, who's a family member, to act as the real estate agent for HOA unit sales, earning commissions even over another director's objections. My request to switch to a third-party management was rejected. Is it legal for one family to hold this level of control? It's unusual, I will say that. They only own 10% of the units, so my advice would be get control of the board. Get the other 90% of the owners to wake up and get some non-related people handling all these responsibilities in your association. Okay, question number 35. A new neighbor with a common wall smokes on his back porch, 18-7. His action is filling my property and townhome with pungent, unhealthy cigarette smoke, and if I open up my porch doors to get fresh air. Our antiquated HOA CCNRs have an annoyance or nuisance article, not non-smoking. Our community manager recently sent him a letter as to neighbor complaints with no relief. As a long-term owner with valley fever, do I have any legal remedies? You probably are considered, if I had to guess, as having a disability under the Fair Housing Act. And so I would approach it from that angle with your association and just indicate that, hey, this is a problem and I'm asking for a reasonable accommodation. And this is a nuisance. It's making it difficult for me to breathe. And we need you to take some sort of legal action to address this nuisance. And hopefully then the association will get more serious about contacting the owner. The owner should not be allowed to do that. If it's creating a nuisance for somebody else, you may want to get an air purification system. If I had to guess, if they're not on their back porch, then they're going to go inside and smoke. So you may want to consult with a separate air purification company too, to give you some advice on how you can limit that, negative impact of the cigarette smoke on you personally. Okay, question number 36. Looks like we've had a couple questions added. So we're down to our last 6 questions. Does the open meeting laws apply to architectural committee reviewing individual homeowner applications? Seems like it runs into an executive session function area. Definitely not an executive session, because it's not, architectural committee is not going to be something that falls under those categories unless like your attorney's involved or there's thinking about suing somebody over an architectural thing. It wouldn't go into the executive session territory. Technically speaking, if the architectural committee is meeting on a regular basis, then it would be required to be, an open board meeting where you'd have to notice it 48 hours in advance. But if it's not regularly scheduled, then you wouldn't have to. Best practices would be to make that an open meeting because it directly impacts other owners, but you're not required to unless it's regularly scheduled under Arizona law. Question number 37. I live in a new community and the management company is allowing rental of the clubhouse space to non-residents without any notification. These events take place 50 feet from my front door. What can I do? Okay, so you live in a new community. I'm assuming that means a newer, like it was just developed, and now management company is allowing rental clubhouse space. I think you probably need to get an attorney to look at your documents to see whether or not this is something that's allowable, and maybe have that attorney write a letter. If you want to contact my office, I'm happy to give you some referrals of attorneys that represent owners to help you with the situation. Question number 38. A lien was placed in 2024 on a property for non-payment of assessments, fines, and fees. The amount owed at the time of the lien has increased since then, although the lien states that the charges due may increase. Is the lien updated with the current amount, or is this automatically done should the property be sold? So if there's a lien on the property from 2024, and that lien should be sufficient, you don't need to keep updating it. And it will be paid when the property is sold, because that lien will need to be released and there'll be a payoff request that's sent to the association. And the association will give them the updated figures, and the title company will collect the money at the time of the sale. One thing I want to mention is that you cannot in Arizona lien for fines. And so want to make sure that's probably, I don't know, put in there that the lien has fines in there. We cannot lien for fines. Just I want to make that very clear. If anybody's thinking about doing that, Arizona law does not allow us to do that. Okay, last 3 questions. Do you have guidelines or advice for board members using social media in their communities? I do. Be careful. Use social media to notify the residents of, the pumpkin patch you're having, or the board meeting, or the annual meeting, or road closures or problems, but don't use social media to fight about issues. So board members should not be commenting on social media. Other than please come to our next board meeting so you can ask this question or hear our response to this issue. So that would be, use it as a communication tool, but not as a tool to, have disagreements with owners and engage in unprofessional dialogue. Okay, question number 40 from Facebook. Great to have you here. Our HOA board recently adopted new architectural standards without providing details or allowing owner input. The standards authorize a 3-member architectural committee, including 2 board members, to approve architectural requests outside of meetings and claim those meetings are closed to owners. A board member also stated that a board can make decisions outside of meetings with only 2 members' approval. Does this violate Arizona open meeting laws, and what actions can owners take? So hard for me to comment on this without seeing your association CCNRs and knowing how many board members you have for your community. But it does seem, I have to look at your documents truly to answer this. First, under Arizona law, one of the architectural committee members who's chair of the committee has to be a board member. That's under Arizona law. And having a 3-member architectural committee with several board members is not unusual. Now, if it's a quorum, if the 2 board members is a quorum of the board, you may have to notice the meeting at the board meeting, even though it's an architectural meeting. I don't like the idea of board members making decisions outside of, meetings with only 2 members' approval. I'm not hearing emergency, and I don't know if 2 members is a quorum or not, but it seems like it's violating the open meeting law. Okay, our last question for today. What are you hearing about turf reduction for HOAs? I've heard about third hand that any day now, HOAs will have 2 to 3 years to reduce down to 10 acres of turf or face state fines. If it does come out, converting lots to turf water-wise scaping will be very expensive and potentially even prohibitive. Go to our website, because I know we have a number of blog articles on the water restrictions that have been in place by the state of Arizona. And so there definitely are restrictions that are in place. Just go to our website, mulcahylawfirm.com. It's mostly applying now to like the larger associations. So I'm not sure it's trickled down to the smaller size associations. And again, this would be like the turf that the association's common area turf. So you'll have to see where you are in terms of your association, how much turf you have, and whether this is going to apply to you now or in 10 years or whatever. But I think everybody can agree that, converting from turf to desert landscaping is something that a lot of associations are considering, talking about for a number of reasons, because it saves money on landscaping costs, saves money on water costs. It's aesthetically, in some cases, more beautiful than having some old Bermudan grass. I personally am from Wisconsin. I love grass, but I think you can have a happy medium in there. A couple things to think about. If you're an association that is thinking about converting from turf to desert landscaping, check with your city, because they have a lot of grants available where it could be 50-50 or 40-60. And the grant money resets typically in July 1st every year. And so you might be able to get the city to partner with you to convert from turf to desert landscaping. It might be an efficient way to save some money for your association. So I encourage you to take a look at the blog article that we've posted here. And if you have any questions, please feel free to contact our office. Okay, wow. We had 172 owners today at peak. That is amazing. So happy to hear that. Thank you so much for being here today. We only have one more virtual class in 2025. Wow, this year has gone by really fast. And that's going to be our December virtual HOA Condo Academy. We're going to be doing it on a different date because of the holidays. So we're going to be combining our First Friday, our firm's live virtual First Friday event on Friday, December 5th, with our December virtual HOA Condo Academy. So we're going to have a twofer. And we're going to be going live on Friday, December 1st at 9 a.m. on Zoom and Facebook Live. And I'm going to be answering any question that you may have. So deck the halls with questions, please. This session is going to be dedicated to providing answers to your HOA or condo legal questions. We're going to be sending out lots of reminders so that we can get as many questions as possible. And that will be our last virtual HOA Condo Academy. Remember, it's going to be on a different day this year. It's going to be in conjunction with our First Fridays, which we've been doing it this way for the past few years, just because the holidays fall. So we hope that you will join us for our last event of this year. Just in my concluding remarks for today, I hope you and your family and friends have a wonderful Thanksgiving. I'm very thankful for my entire Mulcahy Law Firm team and for all of our virtual viewers who come religiously to these classes and want to improve your communities. I hope that you have a safe and happy holiday, and I look forward to seeing you again on Friday, December 5th. Take care, everybody. Happy Thanksgiving.
Don't forget, our free cheat sheets are available for download at mulcahylawfirm.com.
The intent of our Zoom, Facebook Live, First Friday free call-in, videos, and podcast is to provide a forum for board members and community managers to receive answers to HOA and condo legal questions. Please note, the content in these sessions are general in nature and is not intended to and should not be relied upon or construed as legal opinion or legal advice regarding any specific issue or factual circumstance. You should directly consult with an attorney for advice regarding your individual situation.